What happens when the owner of a business dies? So you're in a situation where it depends on how the business is owned that's going to determine what's going to happen. Also, if there are agreements in place that cover situations where one of the owners dies. Now, if it's a sole owner, that's one situation, but if you have multiple owners, whether it's a partnership, corporation, limited liability company, that's a completely different story. Normally, when there's multiple partners or multiple owners, we normally recommend some type of shareholders agreement if it's a corporation, or it also can be called a buy-sell agreement, which is part of a business succession plan, saying that, okay, if one of the owners, if John Smith over here has a heart attack and dies, his kids are not going to take over because they're 19, they don't know what they're doing, they don't know the business. So maybe under his will or his trust, they were normally supposed to get 20% of the company, but you have an agreement in place that says, hey, if these kids are 19 years old, we don't want them running the business or, a 20%, 50% owner. So in that case, we're going to do whatever it is. We're going to retain somebody from the outside, or we will purchase those shares back from that shareholder, from their estate, their spouse, their kids, what have you. So those are the kind of things that you put in writing that will tell you, okay, what's going to happen. Otherwise, if there's nothing in writing, then it can come down to sometimes a probate court. It goes into a court where a probate decides where that ownership is going to go. If there's a will or a trust, then it would go through the terms of the will or the trust, goes to somebody's spouse, somebody's kids, their ownership percentage, and all their rights. That's why it's critical to have thought about these things ahead of time and have a plan in place so that, many times people come in and, hey, we didn't expect this, but somebody got cancer, or they're about to die, or they already did die, and their spouse is going to get 50% of the company, and they don't have a clue anything about the business. We don't want them involved. What do? We're stuck. And if their living trust says she gets the shares and she was a passive owner, then they got to figure out what to do in terms of running the business. So it can lead to a lot of conflict. Also in cases of divorce, that can also come up where a buy-sell or a shareholders agreement, and in a limited liability company, it's called an operating agreement, is where those terms are generally held, in terms of, will somebody get bought out if there's a death? What's going to happen to those shares, and how do we value them? What's the process to buy them back? Or do they get transferred to, their kids or someone else, some outside business interest? So those are a few of the things, but obviously it can be very complicated, and so I'm just kind of touching on the basics of it.